Suppose A purchases the bond.
Yes.
A purchases bonds worth X amount, 100 crores.
Yes.
A is only the person who's been put up to purchase the bond because
That's
that
awesome.
A has a KYC, etc.
Yes, yes, yes.
A has to only physically hand over the bond to B,
Yes.
right? Who's in, or B gives it to C, who will in turn give it to a political party.
Correct.
Now, B, there is no control over the transaction between A and B.
Yes.
So B can trade on that bond for cash or for
Yeah.
whatever other consideration.
Yes, yes.
B acquires that bond.
Yes.
B hands it over to a political party.
Yes.
Or B gives it to C and C hands it over to a political party.
Yes.
The person who has satisfied the requirement of the transaction being through the normal banking channels is A, the purchaser, the ostensible purchaser of the bond.
Correct.
But this does not obviate the fact that the people who are really
Behind it.
yes, that they have used authorized banking channels.
Yes.
All that they have to do is that the
Get somebody's
it
KYC.
says trading is prohibited,
Yeah.
but there is no way you can prohibit trading
Absolutely.
the bond.
Absolutely.
B doesn't have to buy the bond from
No, he
A
doesn't.
through official banking
No,
channels because there is no record of any transactions in the bond. It just goes from hand to hand.
That's right.
Because of the curtain, then you cannot be any questions with regard to quid pro quo.
That's right. And then, ultimately, the person who is actually invested in it is the person who will tell the political party. Who's the holder ultimately?
No. In this case, probably they'll know who's the
Could be
purchaser.
B or C.
They'll know the purchaser, but the actual purchaser is A. B.
Exactly.
Whereas in the KYC etc., A is the one who's.
That's right. Absolutely right. So, it perpetuates.
Also, B may be an aggregator of the bonds.
That also.
By having 10 different people subscribe to 100 different people subscribe to a bonds worth 1 crore each.
That's right. Well, there the human, at least the Indian human mind is ingenious in these matters. We control the economy of the world in many ways. And the RBI raised these concerns repeatedly. We now look at question C, frequently asked questions FAQ, page 138. Question number 36.
128.
138, question 36. My lord has that? Who is the bona fide owner of the electoral bond? PDF 138. Who is the electoral owner of that? Who is the bona fide owner of that bond? Electoral bonds are bearer banking instruments. It's exactly what my lord the Chief Justice said. And the holder of electoral bonds is the bona fide owner of the same. Nothing can be more anonymous than this. All that you need is the KYC, that's it. And then see 17 at page 31, page 131, PDF 131, question 17. Can electoral bonds be purchased multiple times by the same applicant? Yes. Yes, every application will be treated as fresh request for electoral bonds purchased, and every time fresh KYC documents will be given. So you'll have bond brokers, you'll have in-betweens, you'll have all kinds of people participating in this. So it's not just a question of transparency, Malats. It's much wider than that. Last of all, Malats, if I do not know these facts, if I don't get to know the name of the donor, I don't get to know the transaction, I don't get to know the possible direct or indirect quid pro quo, I can't participate in democracy. It is also a matter of participation in democracy. I will then be sued for defamation that you made this allegation without the facts. But how will you get to know? How will I get to know the facts if you hide the facts through an electoral scheme like this? I can't raise questions in Parliament. I can't raise questions outside Parliament. So the scheme, Malats, has no definite objective. If it were a definite objective of funding through the corporate sector, the process of election without funding a political party, I can understand. You can have electoral bonds to fund the election process. But what you're doing here is you're funding a party. It's different. The object is different. So you call it electoral bonds, but these are not electoral bonds. And the limit of expenditure has nothing to do with it. Well, it's 123(6) of the Constitution, of the Representation of People's Act, talks of expenses. Corruption, an act of corruption beyond 95 lakhs now. So the larger issue that your lordships will have to consider that this is no part of participatory democracy at all. Every scheme must have a legitimate object. What's the legitimate object here? Which is constitutional. The scheme must be such, it must be proportionate to the object sought to be achieved. And the underlying principle under the Constitution is free and fair election, which is a basic feature of the Constitution. How are you serving these three purposes, Malas? You are serving none of these three. No legitimate object because it is not limited to the elections. No proportionality because it's unlimited. And no free and fair elections because my learned friend has shown to your lordships how heavily it is loaded towards the party in power. So you are creating a non-level playing field through the electoral bonds. And that's violative of 324. Now, Malas, historically, as your lordship knows, Malas, in 1969, through legislation, we had, Malas, prohibited corporate donations altogether. And then 1985, Malas, through an amendment, we said, okay, the corporate sector can donate, but only to the extent of 5% of the average earnings in the last 3 years, 3 financial years.
5% or 7.5%?
I'm sorry? Initially 5%. Whereas 85 was 5%. Then through an amendment, it was 2013 Act, it was changed to 7.5.
2013?
The Companies Act. Well, actually, I've put it all in the written submissions, but because my learned colleagues are waiting for me to end, so I'm not wanting to take their time, Malas. Your lordships have said that do it, be as short as possible. But whatever I have said to your lordships, Malas, are the propositions that emerge from the scheme itself.
Mr. Sibal's submissions are in which volume?
Volume 1.
Again, volume 1, right?
Yes,
Yes,
volume 1. All the submissions are in volume
there.
1.
Yes, we got.
Then it's page 48.
48.
PDF 48. And if I'll take few minutes, Malas, then I'll be done. Because my learned friends, I want to give them time too. The first, Malas, few pages are just the scheme itself, the electoral bond scheme itself, goes up to PDF page 63. My lords have that. It's just the elements of the electoral bond scheme which have already been explained to your lordships. So I will not trouble your lordships with that. That's been explained. But you come to 63, then Malas, I deal with the issue of free and fair elections under the Constitution. And I say it's the basic feature of the Constitution. And it's now recognized that para 15, Malas, I say, as will be developed below, any nature of funding that is opaque and that seeks to hide the source of funding is contrary to the spirit of free and fair elections, which is part of the basic structure. That's the transparency argument, plus the free and fair in the context of which, Malas, in the context of my submissions before your lordships now. Then election is a vehicle of representative democracy. I've given judgments, Malas, page 66, and then para 17 at 66 is the constitutional mandate of free and fair elections under the principle of universal adult franchise is the central pillar of our democratic culture. Under our political system, elected representatives do not have any political legitimacy independent of the will of the people and must discharge their duties in public trust. But it must never be forgotten that this Constitution is citizen-centric. It is for the citizens to decide to donate. If you want corporate funding, then that corporate funding must be for the electoral process. It must not be for political parties. Otherwise, it will not be free and fair election. Then, therefore, Maras, you must interpret superintendent's direction and control of the conduct of elections in that context. That's set out at page 67, end of paragraph 19. Then I differentiate between freedom and fairness, which is para 20. I won't, Maras, trouble your lordships with the language. And para 24, I say economic power at page 68. Economic power presents a grave risk to any level playing field between individual citizens and groups and can give some voices a disproportionate say in deciding the agenda of the political parties and hence the laws and policies that will govern the entire country. In pluralistic democracies like India, practices must emerge that preserve the equal voice of all citizens and that ensure that the special needs of all groups are heard. But if the voice of the corporate sector drowns the voices of citizens, that's a very dangerous trend in democracy. Then, Justice Bhagwati's judgment in Kamalnath Gupta's case, let's leave that out. I think that's one extreme position which I don't want to argue. And then, then this is important. Kindly see, para 36 at page 72. Reiterating my learned friend's submission that it's the voters' right to know. That's fine. And this whole concept of black money, I mean, I don't understand. The cash that is given below 2,000 can be black money. The 20,000 rupees has to be disclosed, that also can be black money. Because you can say cash in hand, 20,000 rupees. And the electoral bond can also be black money. And over and above that, there is black money. Because there is cash that doesn't go into electoral bonds. So what is this black money issue about? The kind of extravaganzas that we see, mothers, is what? Is it white money? So this has nothing to do with black money. This is the case of the government. That black money was used earlier, no doubt. Black money is used today, no doubt. There is more cash in the market than it was in 2014 or 2019. That's government's own statistics. So black money is a bogey. And all three elements can be part of black money. That can't be an argument. So dealt with. And then, so the three issues, Malas, I have raised at page PDF 75, whether corporate donations should be allowed at all, but that's not a question that your lordships has to answer. If yes, what kinds of companies should be allowed to make such donations? If corporate donations are allowed, what cap of net profits should be set? And who is the appropriate body within the corporation to authorize such donations? That's if you agree to all what the other side says. If you agree to what the government says, then these questions will arise. But that's subject to my submission that I've made to your laws. The shareholder argument, I've placed there, paragraph 43, the objects of the company and all that, which I've already commented upon. Then I've given the history. Then 2013, my lord asked the question, the cap of 7.5, that's at para 47. And actually, there's a wonderful report of Justice Shah, I think at the Law Commission, which actually sets out the practices in all the countries, UK, US, Japan, Philippines, Australia, and Germany. And in all those countries, there is no question of any opacity. Most countries do not allow corporate donations at all. But where they do allow, there is no opacity. And this is all at PDF page, your lordships may only note it, 296 in volume 4. That's really it, Malas.